Good morning, everyone. It's a pleasure to welcome you on this very crisp morning. We are delighted to be hosting this webinar on ending the two-tier workforce and the implementation of the Employment Rights Bill, which was, of course, very recently introduced to Parliament. I'm Clare McNeil. I'm Director at Timewise, and I will be our chair for today. This is the first of a series of events we're holding as part of our Industry Voices programme. Which is supported by the Aberdeen Financial Fairness Trust, and which is asking how we can create better access to secure and flexible jobs for people, particularly in low to middle income households. Before we start, just a quick recap about Timewise. Our mission is to create healthier, a more equal workforce where everyone has access to good quality, flexible and secure work. We do research, we run campaigns, and we work directly with hundreds of employers, particularly in the service sectors of the economy, such as retail, healthcare, transport and logistics, where it can be more challenging to create flexible and secure work. Over the past year, we've been carrying out interviews, holding focus groups and roundtables with employers, with unions, with sector bodies, to really focus on what works in these sectors to improve job quality, and also to understand how this can be scaled up to reach more workers. And we'll be publishing our findings in the coming weeks. Just a bit of housekeeping. Do feel free to tweet and extra points if you use our snappy hashtag, which is End Two-Tier Workforce. So in terms of our focus for this morning, the government's Make Work Pay agenda aims to be the biggest upgrade for workers' rights in a generation. This is urgently needed in our view because there's a growing gap between those who are able to take advantage of the growth in remote and flexible working that we've seen since the pandemic, and largely shift-based and site-based workers who have much less control over their hours and their place of work. Far too many people still don't have access to the flexible work that they need, and fully 60% of employees, which is the majority of the workforce, of course, are in site-based jobs that cannot be done from home. And many of these same workers are on insecure contracts where over half typically receive less than 1 week's notice of their shifts. So why does this matter? Because as we know, job security and having a degree of control over your working hours is strongly linked to both your health and your job satisfaction. And you probably don't need to tell me to tell you that on both of those counts, on health and on job satisfaction, particularly for low-paid workers, outcomes are getting worse. So to help us understand what the Employment Rights Bill may or may not achieve in resolving some of these issues, we are joined by a fantastic panel of speakers. I'll briefly introduce them all before going through a few of the questions that we'll be focused on for the discussion. So firstly, we have Professor Alan Bogg, who is Professor of Labour Law at the University of Bristol and a barrister at Old Square Chambers. Cominetti, who is Principal Economist at the Resolution Foundation. Alice Arkwright, who is Policy Officer at the 2UC and has very kindly stood in for her colleague Vic Jones. And finally, Amy Butterworth, who is Director of Consultancy at Timewise. So we'll hear from each of the panel before moving to a discussion and questions from you, the audience. So please do be thinking about your questions, and we'll have the Q&A kind of function for those when we get to it. So just a few highlights from the bill in terms of the proposals that we're particularly focused on. Lorna, if you want to bring up that slide. So just, I won't run through these. I'm sure each of the speakers will go through them, but we're particularly focused on those proposals that concern kind of greater predictability and flexibility at work. We're also interested in the Fair Pay Agreement, because that's focused not just on pay, as we know, but also on terms and conditions in social care. So there's a lot to consider, and just moving on to the next slide in terms of the questions that we are focused on. We're really interested in understanding the implications of the bill for employers in relation to flexible and secure work in particular, understanding how employers may respond to the legislation, but also, what's needed alongside the legislation to ensure that we see the step change that we need in terms of access to good quality work. So I will hand over now to Alan, our first speaker. Alan, over to you.
Thanks very much for the invitation, and it's a real pleasure to be speaking at a Timewise event. I think the work that you do is fantastic, and when I come to the end of my short set of reflections on the bill and the provisions in the bill, I can circle back and think about how the bill could be improved by engaging with some of the work I think that Timewise has been doing very effectively in this space. I should open up by saying I might have a few critical remarks to make on the provisions in the bill, but overall I think it's fair to say that it's a game changer for flexible and secure work in labour markets. So as you can probably see from my grey mop of hair, I've been around for quite a long time. And I'm old enough to remember 1997 and 1998, which was the kind of last moments, I think, where there was a real opening for transformative change in labour market regulation. And I think where we are now with this bill, I think is much more significant than that moment. So I think there are two sides to the flexibility security coin in the bill. The first is in clause 7, which is the right to request flexible work. And what the proposal in the bill does is it bolsters that right to request. So now it would need to be based upon a reasonable objective test, rather than based on the employer's subjective belief that one of the grounds for refusal applies in this case. So it's still a right to request model, but what that does effectively is it imposes a stronger duty on the employer and opens its refusal up to more substantial scrutiny, because it has to be based upon reasonable grounds. And I think that's an important and valuable development in making the right to request a reality for more workers. Now, alongside that, as has already been touched on, you've got a number of provisions that relate to low hours or 0 hours contracts with a significant variable hours component. And what the bill proposes to do is give workers a right to guaranteed hours, a right to reasonable notice of shifts, and payments where shifts are cancelled or curtailed without reasonable notice. Now, crucially, the right to a guaranteed hours contract is not a right to request a guaranteed hours contract. It's more significant than that. It's a right to the contractual variation. If you have a 0 hours or a low hours contract, you will have a right to a contract that reflects the number of hours that you actually work, as defined by a reference period, still to be worked out through secondary legislation. And that's a very, very significant step. Now, I think that that's broadly in the right kind of ballpark if you're serious about tackling exploitative 0 hours contracts. The government, I think, has been criticised for not banning 0 hours contracts. I think that's been viewed as a kind of slippage from an earlier commitment. So the discourse is now around exploitative arrangements. From my own perspective, I think if there's a genuine preference for a variable hours contract, then that ought to be respected. The problem is if there isn't a genuine preference on the part of the worker. So I think that distinction between exploitative and non-exploitative arrangements is the right distinction, and I'm not in favour of prohibition if you can formulate rules that draw that distinction, and that's what the bill is trying to do. Now, to leave you with two sort of difficulties that I think the legislator will need to think about as the bill progresses through Parliament. The first, and this sort of comes back to Timewise's work, the first is to think carefully about sectoral challenges in this context. So there are some sectors like health and social care, transport and logistics, retail and construction that rely very heavily on variable hours contracts. And I think there needs to be very careful thought about how this right to a guaranteed hours contract will translate in the context of sectors where there is heavy reliance. And it may be that there needs to be some kind of sectoral adjustment so that employers have a chance to think creatively about their working time arrangements. I think the second issue, and I will finish here, is it's an individual right to request guaranteed hours. You're not under a duty to request them, but you have a right to request them. So imagine you have a workforce where half of the workforce makes a request for a guaranteed hours contract. You then have the other half of the workforce who continue for good reasons for themselves to work on 0 hours contracts or low hours contracts with a variable component. If there is a sharp downturn in work, and of course legislation can't magic that away, I see the predictable effect of this will be the costs will be carried by those on 0 hours contracts. So effectively, you've got the recreation of a two-tier workforce in virtue of this legislation. Now, I think the answer to that is that there needs to be, alongside the individual right, some kind of workforce agreement or consultative mechanism so that what might become a zero-sum game between flexible workers and workers on guaranteed hours can be dealt with more fairly, and the risks of unavailability of work can be distributed in a fair way across the workforce, because I think it would be a pity if 0 hours contract workers who preferred that arrangement carried the can if there was a downturn in work. So I think there needs to be a collective mechanism alongside the individual mechanism.
Great, thank you very much, Alan. Really helpful overview of the proposals and also some of the complexities. And it's fair to say that the need for collective arrangements alongside the individual focus of the legislation has definitely come through in our work as well. Nye, over to you.
Well, thank you very much, Claire, and thank you for inviting me today. Just for everyone listening, if I sound a bit hoarse and very whitish, it's because I woke up yesterday with COVID and a broken boiler. So forgive that. The boiler's now fixed, but the COVID's still here. Thanks for inviting me along today. I think the tone that Alan just struck there, I think, is the right one. It's kind of easy for us in the world of people who've been thinking about these issues and arguing, for some of these changes, to be a bit impossibilist and say, well, you haven't quite got this bit right, and point to all the things that are being gotten wrong. But I think the onus is on us to engage, positively, proactively with these changes to try and work through all of the nitty-gritty detail, rather than to sort of carp on the sidelines, having, the government having now taken the plunge, as it were, to push these changes through. So I think that this kind of event and those kind of remarks are really helpful. Not least, over the next few weeks and months, the government's doing lots of consultations already on various bits of this, and I think there'll be plenty more consultations in the future. So, yeah, there's definitely a big job for Timewise and a vast mass ranks of lawyers as well. I thought I'd just say a couple of things about the big picture, but along the lines of where, this big problem that you presented, Claire, two-tier workforce, how much is the proposal in the bill solve those problems? What has been left out? And then maybe a couple of comments at the end about kind of risks and trade-offs. So in big picture terms, I think two-tier workforce is a really good framing, because a lot of what these measures are doing are extending to low-paid workers the kind of entitlements, flexibilities, good aspects of work that many of us take for granted. So I think sick pay is a really good example of this. So I work in a professional job, I sit at my desk, doing research, writing emails and so on. If I'm sick, I have the option A, to work from home if it's not too bad and I can, scrape through and continue doing some emails. But if it is bad and I'm too ill to work, I just won't work and I'll continue to get paid as normal. That is just a basic fact of working life for the vast majority of, well-paid, white-collar jobs. But it isn't for low-paid workers. And I think this is literally something that many people are literally unaware of, that there are low-paid workers out there who, when you fall sick, you don't get paid as normal. So I think anything that pushes in that direction is absolutely right. Just to give the sick pay example, I was speaking recently to a company who had given their cleaning work, also they run building services, including cleaning. They'd given their cleaners access to full sick pay and also the ability to take time off in the middle of the day to attend GP appointments. And they spoke very, very positively about how that was received, the impact on the workers' health. They think it was net positive because it meant the workers could stay on site, do an online GP appointment, sort out their medication, pick it up at the end of the day and carry on working. So it was less disruptive overall. It did come with costs, but anyway, so I think that is a good framing and the right way for us to think about this. Does the bill go far enough? Has it solved all problems? I think in some areas it looks very ambitious and very impressive. And I think those right to guaranteed hours, right to compensation if your shift is cancelled at late notice, I think those are very ambitious proposals and will have a very big impact on workers in those groups. Yes, there are questions about exactly how those laws will work in practice, but I think it's clear that the government's got a big ambition there. On some areas, though, I think they haven't gone as far as I would have liked them to, and I think sick pay is the most obvious example. So the reform on sick pay is that they will end waiting days in statutory sick pay. So currently, if you're not entitled to any sick pay at all until your 4th day off sick. Now, maybe that doesn't matter too much if you have a very long sickness absence, you miss those first few days, but then on an ongoing basis, you're covered. But most people, when they're sick, it's for a few days. You have a cold, you have a flu that knocks you out for a few days. And so most workers in most sickness absences aren't covered by the statutory sick pay system at the moment. So getting rid of sick days, which is what the government wants to do, it's a really important change. It will extend coverage to more workers. The other thing they're doing is getting rid of the earnings threshold that you have to pass before you get entitlement. I think that's important for many women working part-time. Women comprise the vast majority of part-time workers, especially those on very low hours, and those workers will now be entitled to sick pay. The thing they're not doing, the government, is changing the level of sick pay. So the UK will continue to have a very low level of sick pay compared to most other rich countries. I can't remember the exact number, sorry, I think it's roughly £120 a week at the moment. And average pay for someone on full-time work is in the I think it's £500–600. So clearly you're still going to face a really significant earnings hit and income shock if you're at home sick. So in that respect, I think we are not ending the two-tier workforce with the measure. So I would have wanted the government to go further in that respect. I think I've already used most of my 5 minutes. Briefly on risks and trade-offs. So I just wanted to say that there's kind of this big debate at the moment. You have these proposals going through, and then you've got business groups at the one side saying, this is all risk. If you do these things, unemployment's going to rise. You're going to put small businesses out of work and so on. And then on the other side, you've got kind of progressive left-wing types, which maybe I'm in that camp, saying, actually it's all win-win. You raise job quality, it's better for workers, they can be more productive, and it's kind of a virtuous cycle. I think the truth is in the middle. I think there are risks, but we just don't know at what point they're going to find. And basically, that's the story of the minimum wage over the last 20 years. 20 years ago, we introduced the minimum wage. Businesses said, this isn't going to work, it's going to cost jobs. We're raising the price of labor. Obviously, we're going to want to hire fewer workers. That didn't happen. It turns out there was enough employer power in that market that if you force them to pay more, they were still happy to take on those workers. The question is, can we continue to pull up that trick? Can we continue to raise pay, raise terms and conditions without costing jobs? And fundamentally, that's an empirical question. We don't know until we do it. So that's why you have bodies like the Low Pay Commission need to, conduct research, look at the evidence, and find out what's going on. So I think that is the spirit with which we should all be engaging with this problem. It's, there are trade-offs. We don't know where they will sit until we undertake these policy reforms, which we absolutely should. I think I'll end there, if that's okay, Matt.
Great, thank you, Nye. And just to come back with kind of perhaps one quick question based on Resolution Foundation work. I mean, Alan touched on the need for kind of workplace and collective agreements, and Resolution Foundation has done a lot of work advocating for more of a sectoral approach, good work agreements where you bring together institutions. And I think, you know, our work has shown that we have really weak set of institutions at the level that we might need them. So what do you think on that point about more of a sectoral set of agreements and negotiations?
Yeah, I think that's right. It's definitely one of the most interesting parts of the proposal. So I think they're right to start in social care, because that's where you have a lot of workers potentially in the sharp end of employment entitlement abuses, most obviously the minimum wage. So you know, the minimum wage is the hourly rate of pay below which your pay can't fall. But you have lots of domiciliary care workers who are driving around, and it's always a bit unclear if that driving time counts towards your overall working time. And some calculations we did in the past suggest that probably quite a few domiciliary care workers, when you take account of that time, their pay does fall below the minimum wage. But it's really hard for those workers to do anything about that, because most of them aren't in unions. So although they're delivering a public service, mainly the social care workforce is in the private sector. And secondly, they are what's the word? They're not hanging out with each other in canteens. You know, so it's hard for workers to compare notes. When we did some focus groups with care workers, it was fascinating, because this was among the first times that these, and it was mainly women, but had the chance to sit down and say, hang on, you're paid like that. I didn't know that was an option. I'm going to go and speak to my employer. So I think when you have that kind of separated workforce facing a common set of issues, it does make sense to pursue collective approaches. There are risks here, so I think this is not, you know, this is quite a big institutional change. We used to have collective bargaining in this country via you know, industry pay bodies. Those went away in the 90s, and so for the last 20 years, it's everything in the labour market, really, for most things, have been done on an individual basis. You know, we have individual entitlements, and if those are upset, you have to individually go to an employment tribunal. So it is a very big change in approach, but I think the government is right to pursue an experiment in that direction. Last thing to say is there are risks though. So New Zealand was a trailblazer in this area, and a few years ago they put in place fair pay agreements. But I would say they never really had the full buy-in across politics and across, you know, business and workers. So another government came in and they scrapped it all. So I think if you're going to do this, you do have to move slowly. Make sure you have the buy-in of all the groups involved.
Thank you. It's a really important example to bear in mind. Alice, over to you. Alice is the flexible working lead at the TUC.
Thank you very much, Claire, and thank you very much for having me. Apologies from my colleague Vic Jones, who was meant to join. Unfortunately, she's had to take some emergency leave. But thank you for having me. And just to start from by saying, to echo the other points, this is one of the biggest upgrades of employment rights we've seen in a generation. The union movement has really welcomed it as a step forward in the government's Make Work Pay agenda to tackle some of that unfairness in the labour market that the other speakers have addressed. I'll focus my comments on flexible working, as that's what I work on at the TUC, but there are many aspects of this bill that will address some of the insecurities in the labour market. In terms of flexible working, the TUC, alongside organisations such as Timewise, who do brilliant work on this, have campaigned for a long time for more access to flexible working and more equal access to flexible working across the economy. What we've seen since the pandemic is this kind of quite rapid growth in home and hybrid working, but that has not translated to a growth in people managing to access other forms of flexible working, so particularly frontline workers in hours-based flexible working. And just to draw on one example of why this is so important, for example, our unions in our health sector, so our NHS unions, have been doing a lot of campaigning to show that the lack of flexible working in health is driving people out of the profession. And it is also driving workers into bank and agency staff. And there are kind of many downsides to this in terms of, for workers themselves, bank and agency staff don't get the same terms and conditions as an Agenda for Change NHS worker. But also agency work costs the NHS money. So there is this urgency, I'd say, to get that flexible working into those more front-based roles where there's less likely to access it. And to give one example of that, a quarter of midwives and maternity support staff surveyed by the Royal College of Midwives said an agreement to work flexibly could encourage them to return or stay working in the health service. I won't spend lots of time talking about the benefits of flexible working. I think everyone on this call is probably in agreement on why it's important. So what does the Employment Rights Bill do? Alan covered some of it in relation to flexible working. And this comes off the back of the changes that we saw in April 2024, which introduced a day one right to request alongside some other measures. The Employment Rights Bill itself, it adds that reasonable test. So it will create a requirement on employers to explain why a rejection, if there is one, is reasonable, as well as the current requirement to set out a business reason for a rejection of a flexible working request. And then off the back of that, there'll be more scrutiny, as tribunals will now be able to assess whether a decision was reasonable, in addition to whether the employer took reasonable steps when looking at the request. There's also provisions in the bill for the Secretary of State to set out steps that employers must take to show they have consulted with the employee. So the April changes brought in introduced a requirement to consult with an employee if a request was going to be rejected. So the Secretary of State will be able to set out what that process should look like. So as Alan said, this creates more scrutiny around an employer's response to a statutory request to flexible working, and it will kind of increase the requirement to show that a response to a flexible working request is fair and has taken into account all measures that the employer should be looking at. We'll go through a phase of consultation on this, probably likely in 2025. And that's where I think some of that detail around the steps of what consultation will look like will come out, questions about kind of reasonableness and what that looks like. So in terms of, does this make flexible working the default, which was the kind of aim set out in Make Work Pay? So this is an important step forward. We know that too many requests are still rejected. We did some research very recently that showed half of dads and partners had some or all of their flexible working requests rejected. And in terms of improving that process, I think there are some clear benefits. It will support greater transparency and trust in that process if there's a higher requirement to show that the request has been dealt with reasonably. The consultation process draws in the worker's voice into that dialogue around whether the flexible working request can work. And then also be that greater scrutiny on the decision, meaning that employers will need to demonstrate a greater understanding of job roles in terms of how the flexible working request might work. The greater clarity in processes also allows to address some of the potential unfairness or discrimination that we might see when flexible working requests are dealt with. But I think one of the biggest barriers is that it's still rooted in an individual request. So we know that many people are still put off making flexible working requests. Our research showed that a survey of 13,000 working mums, 4 in 10 said they wouldn't feel comfortable asking in a job interview, and around the same wouldn't feel comfortable asking in the job. And Timewise, I think, have done some brilliant research that showed that BME workers were more hesitant about talking to their employers about changes to their working arrangements. So I think if we're wanting to move into a more collective space, there's some clear things that employers can do to encourage that in their workplaces. I think the first one is having collective agreements. If we have collective agreements on things like flexi time, team rostering, other forms of flexible working, it reduces the chance that people need to make that individual request in the first place if there's that collective agreement to start with. One of the big things the TUC has campaigned on is for advertising flexible working options. So for employers being upfront about what flexible working is possible in a job when it goes out to hire, it means there's greater transparency and understanding between the employer and the worker before they start the job around what's possible. I think this works for both sides. It means when workers are applying for a job, there's that really clear commitment that it's going to be able to work with their life. And from the employer side, you're not going to hire someone and then 2 days into a job they ask for something that's simply not possible, and creates that kind of almost point of tension kind of very early on in a job. The other point here is, and I think a lot of organizations talk about this, is around job design. So thinking about flexible working at the first point rather than later on when someone asks for it is a really important measure employers can take, I think, to make these new legislation a reality in the workplace. And I would say when doing that, it's really important to assess. We've all talked about the inequality and access to flexible working. So it's about assessing every job role through the pay scales, through grades, to make sure that that flexible working offer is looked at across the workforce and not just in certain roles. I would say this, but recognizing a union is a really important part of this process. I think you have then reps that come from your workplace. They are members of staff that employers have hired. They are really important actors in that role of getting those collective agreements. You have people in your workplace who will understand the job roles, understand the people, and they can work with employers to bring in those collective procedures, to bring in that transparency around what's possible, and to have those conversations around job design. I'm probably already up to my 5 minutes, but the final point I just wanted to make was the Employment Rights Bill is also bringing in may require employers with over 250 staff to publish a plan to address gender pay gaps and support employees through the menopause. And I think flexible working is really important here as well. We haven't had the more detail on that, but also we know that we're expecting legislation around ethnicity and disability pay gaps here. And again, flexible working can play a really important role in reducing those pay gaps. So I think one aspect for those action plans is reviewing those flexible working policies, but also collecting data. So understanding in your workforce who has access to flexible working, who feels comfortable asking for it, who is getting it, which job roles are already flexible. And that may provide some of the answers to the problems those action plans are trying to solve.
Thank you, Alice. That's a really rich set of insights. And I definitely agree that our research with low-income workers we've spoken to as part of this programme shows that it's often those workers we most want to be comfortable to ask to make these sorts of requests that are least likely to. So that's a real challenge to think through. Do be thinking of your questions. We'll have some time for those at the end. But Amy, over to you.
Thank you, Claire. Morning, everybody. So just to add, really, I guess, the Timewise view, following what colleagues have shared already on the call. You know, the Employment Rights Bill, I guess, in its entirety was set out as a way to even out the balance of power in the workplace and give more protection to employees than they currently have. And we do particularly see the scales tipping in favour of employees in elements such as some of the day one rights, so protection from unfair dismissal, the sick pay provisions, which Nye has mentioned. You know, the plan to make work pay from the very beginning called out the current widespread one-sidedness of flexibility within the labour market at the moment, and did make a strong case for both the benefits to business and to the economy of giving greater flexibility, greater predictability to our workers. As you'd expect for Timewise, a particular interest to us within the bill is the commitments that the government's made around approach to flex and approach to 0 hours contracts. And we do really welcome the commitment to making flexibility a default way of working, the greater onus on employers to agree to requests, and that reasonable objective test, which Alan and others have talked about this morning, which is really sort of raising the bar and raising the requirement on employers. We are also pleased the government's taking action to tackle unfavourable 0 hours arrangements, giving workers the rights around payment for short notice cancellation of shifts, so curtailed or moved shifts. And, you know, we work in sectors like social care, in hospitality. We know that these changes will give a lot of workers more security and more regular work, notwithstanding some of the challenges around implementation that have been mentioned about, you know, potentially retaining some people on 0 hours contracts and what that then means when when employers are looking to reduce staffing levels. And we also really welcome the focus on gender pay gap reporting and the introduction of the equality action plans, which Alice just mentioned, because for us, this is really a way of recognising that employers should be addressing the barriers which hinder women's progression in the workplace. And in our view, that includes flexible and part-time working. So there are lots of things that we are very supportive of and things that we're pleased to see. And I guess the question, as others have articulated this morning, is whether this collection of measures goes far enough to really challenge that anti-flex rhetoric, which we are just hearing loud and clear in UK media, particularly at the moment. You know, at Timewise, we have the privilege of working with employers across a range of sectors. And we do know that actually a lot of what's contained in the legislation does happen already amongst proactive employers. So the focus from our perspective really needs to be, how can you sell this to the more cynical employers? How can you use these legislative provisions to drive up change across all organisations? And make it clear that there are business benefits to flexible and secure work, not just social benefits. We did consult as part of the Industry Leaders Programme of which this webinar is part. We did consult with a range of employers in frontline and site-based sectors, and they were generally supportive of the changes, but I think felt that the legislation alone was unlikely to lead to a step change in access to flexible working, particularly for individuals in site-based or shift-based roles. And we also convened a worker panel through this programme, and they told us how important it is to build awareness of these enhanced rights amongst employees, and really that it's the behaviour of leaders and managers that has to change, because they're the people who will really determine how these legislative changes do or don't take hold in workplaces across the country. As others have mentioned, one particular challenge that we at Timewise see with the forthcoming regulation is that it still does rely on that individual making a request. And you know, other colleagues on the session this morning have shared ideas about ways you might tackle that. You know, even when employees understand their rights, which, as I've said, you know, our worker panel tells us isn't a given by any means. We know that workers often lack confidence in expressing their preferences, and that's where that individual request response framework for statutory flexible working arrangements really falls down, because people fear it might harm their career if they ask. People fear they won't be offered shifts if they ask. They fear they'll, you know, fall down the pecking order in terms of a manager looking at their team of employees. So really, you know, would support what Alice was just saying in terms of suggestions around, you know, employers becoming more proactive and almost reducing the burden on the employee having to ask. And, you know, we do work with some really proactive employers who look at, you know, different shift options as standard, who engage employees as standard in expressing their preferences. But alongside that proactivity, it is going to be key to get the guidance accompanying the legislation right, to try and make sure that employers are genuinely supportive if someone makes a request, and that, you know, managers feel a shared responsibility with their employees to think about how they can organise work differently. So at Timewise, we do want to see the code of practice which accompanies the legislation really do as much as it can to strengthen that move towards flex by default, which was the, you know, the espoused aim of this piece of legislation. We would like to see a legal duty placed on employers to consider what flexible working arrangements are available in a role, absolutely to include those in job advertisements, which Alice mentioned, and employment contracts from day one. We'd also like to see strengthening of the consultation requirements, so that if an employer declines a request, they not only have to kind of explain that kind of reasonableness test, but also need to identify what alternative flexible arrangements they've considered and be able to offer those. And we would like to see employers required to report, certainly internally, on the types of flexible working and contract types that they have within their workforce. We think that that would help inform employees and demonstrate what's possible. And we'd also like to see employers encouraged to report on flexible working as part of their equality action plan. So, you know, in summary, I guess from the Timewise perspective, it is great to see the bill highlighting the need for good flex as default, and, you know, addressing some of the current challenges around unpredictable 0 hours arrangements and gender pay disparities. We think there's still quite a lot to play for as the code of practice is developed, and that will really establish the expectations and requirements. And I think if employers really want to deliver the spirit of the legislation, they're going to have to think much more inclusively about access to flexibility beyond hybrid and desk-based flex, and really look creatively at how they can redesign work for all of their different workforce groups. I'll stop there.
Great, thank you very much, Amy. And just say we'll be publishing those and other recommendations in our final report in upcoming weeks, so do look out for that. Just a few questions from me, and taking in some of the questions we've had from participants. I mean, so overall, stepping back, there's a lot of positivity here that the claims that are made for the legislation in terms of how game-changing it is are justified. Just to play devil's advocate for a few minutes, we've also heard a bit about some of the weaknesses and some of the detail that still needs to come through, and obviously we'll do through the consultations. Just on flexibility by default, we've had a question here asking about you know, whether the changes will really deliver on that. And Alan, perhaps a question for you. I mean, the role of the code of practice alongside this seems very important here. You know, without that, is there not a danger that we could be looking at a situation where, you know, we're relying on sort of litigation over the next few years, case law, for firms and workers to really understand, you know, what this means? So what do you see as the importance of that code of practice and the new powers for the Secretary of State that have been issued alongside the legislation?
Thanks very much. So I think that's a point that recurs across the bill. So it's an extremely ambitious piece of legislation, but because of the time in which this was undertaken, i.e. the first 100 days, and because of the scale of what was attempted during that 100-day period, so much of this is going to depend upon secondary regulations and codes of practice. Now, I think the advantage of a code of practice, and you see this, for example, in relation to the recognition procedure, in relation to disciplinary and dismissal procedures, is that there can be a more kind of nuanced and narrative account of how workplaces can engage creatively with legislation. So statutes are formulated in very sparse, laconic language, and that's because they have to operate as rule of law guidance, whereas codes of practice, I think, can just give a bit more flesh on the bare bones of the legislation. And I think that's why it's so crucial for groups like Timewise and the TUC Resolution Foundation to be fully engaged in that process, because in many respects, codes of practice are probably more important than the legislation itself, even though the code of practice is not in itself a legally enforceable document. But I think, you know, often that's where the action is, rather than the words in the statute itself. So I agree with that kind of insight.
Okay. And we've been asked about sort of get out clauses and concerns about that. So a similar point. And now I know that you've done a bit of work looking at, in particular, the proposals around 0 hours and some of the sort of challenges with implementation. So do you want to come back on that?
Yeah, so I think that the hardest part of all this, when you in terms of thinking about, you know, trade-offs and risks, is, well, sorry, the easy bit, which the government at times sounded like was their focus, was giving contractual security to people who have that security in practice anyway. So maybe they're on a 0 hours contract, but in practice they're on a very, you know, steady number of hours. And this is true of many works in social care, because demand is so high. Maybe they don't have that control over exactly when their hours are. But when you speak to social care workers, relatively few would say, I'm worried about how much I'm going to get paid next week. Am I going to get shifts cancelled? It's more about control over when those shifts land and that kind of stuff. But you know, their jobs look pretty regular. Their pay is, you know, for the most part, for many workers at least, very regular. That doesn't mean that the lived experience of that control could be improved. It's only good. But so and that I think you could describe nurses as resembling that as well. So contractually not secure, but in practice, you know, their hours often reasonably stable, reasonably steady. So the government, in many of its interviews, sounded like that was its focus. You know, for the workers who are on a 0 hours contract, it really shouldn't be. We'll give them that secure contract and give them that, you know, peace of mind, I suppose, and also stuff like helping them access mortgages and things like that. But the harder group is people whose hours genuinely bounce around, who face genuine volatility, and who are working for employers who face genuine intermittency of demand. So not someone running not a hospital, you know, where they can reasonably well predict who's coming through the door in a given week, not a social care provider, but let's say hospitality is the most obvious example. And that could be, you know, a catering company. They don't know what their booking is going to be from week to week. So when I did a paper on this recently, I said, you know, this is the group who could rightly say, you know, this is really going to make our lives difficult from a business perspective. It's going to raise our costs if we have to keep on workers at a higher level in a given week, but we don't know if we're going to be able to put them to use, as it were. So then the question is, what do you do about that? Do you do carve-outs, sector carve-outs, or do you just say, you know, that is kind of the hard bit? And I honestly came down on the fence of carve-outs kind of open such a big what's the right word? Can of worms, slippery slope. Sorry, my analogies are failing me today. But I think that kind of gives rise to so many questions, and that's exactly where business groups will then insert themselves and try to sort of prise that window as open as they can. So my feeling was, in the first instance, you have to be honest and say, yes, we're aware that we're going to, you know, make life difficult for those employers. What can you do? You can give them lots of advance notice. I mean, that's already baked into these, to the passage of these reforms. A lot of it isn't going to take effect for at least 1 or 2 years. But, you know, when you know the shape of it, can you give employers as much advance notice as possible? But then thirdly, you might just have to accept some trade-offs. So it might be that hospitality becomes more expensive because labor costs are higher. And it might be that we end up as a country consuming a bit less hospitality. Maybe we have slightly fewer hospitality businesses. So personally, I'm happy to accept some of those trade-offs, but those are definitely where the difficult conversations are to be had.
Thank you. There's lots of questions coming in now. One on what we can do to protect agency and bank workers. Obviously, there's a consultation on that in relation to 0 hours. Alice, you mentioned the sort of the lack of flexibility in mainstream roles can encourage more people to end up on bank and agency contracts. Do you want to come back on that question?
Yeah, of course. So what we hear from our unions, particularly in the public sector with the example I gave, is that the lack of flexibility in some roles within the health sector, but we've also heard this in education as well, is then forcing people to move into bank or agency or in education supply work in order to get that flexibility. But the problem with that is that those jobs, the supply, the agency, the bank, don't come with the same secure terms and conditions. So I think part of this, in terms of increasing the legislation around flexible working, is making sure that flexibility is possible within those jobs that have the secure roles. In terms of when we look at agency staff, I mean, to look at the fair pay agreement in social care, that will, as far as I'm aware, cover agency workers within the sector as well. And I know that unions have been pushing rightly for that fair pay agreement to include all staff that work in social care. So not just your kind of core social care workers, but the cleaners, the additional staff that would come into that, to ensure that those kind of workers are also protected through this new legislation. I think there's still questions around agency workers and 0 hours contracts. I think, as we've referenced, this consultation period will be really key in drawing out some of those questions. And I think the fact that they've had to push this legislation through in 100 days just means that some of it is shifting over into those consultation periods and that second process. So yes, I think it's key that we kind of improve the flexibility and security in jobs where people are, so they're not forced into this insecure work. but then also kind of protections for those agency workers as well. Just to say on that as well, we know that most people on 0 hours contract want a secure guaranteed hours contract. I think there's sometimes a narrative that a lot of workers prefer being on these 0 hours contracts. A lot of our research shows that the majority of people would prefer to have a guaranteed hours. My other hat in the TUC is young workers, and we also hear a lot that 0 hours contracts benefit students who will overwhelmingly work in things like hospitality. We heard through our polling that it was over 8 in 10 students said that being on a 0 hours contract disadvantaged them when it came to balancing their education and their work. So there were real clear disadvantages for workers trying to figure out their lives around work when they can't have these hours week to week. And I think that translates into sectors like hospitality as well.
Thanks, Alice. And we've had a really important question come through, I think, which touches on, what is the accountability here, and what should employers be required, if anything, to be reporting? So the question is, should we be asking employers to be more open about the flexible working requests that they're accepting and declining? Because without that, it's very difficult to know how impactful the legislation may be. So I'd just like to come to each of the panel on that particular question around accountability. We know that there will be a Fair Work agency that is being established that will incorporate a number of existing responsibilities, but many of these issues are contractual. So what do you think the picture should be there? And Alan, I'll perhaps come to you first on that one.
I think that the danger with reporting requirements is that they can just become kind of bureaucratic box ticking exercises. So I think that's the risk in thinking about accountability in narrow terms. I think the thing that really emerges from this discussion for me is a need to think about working time very differently. We're accustomed to thinking about this as an individual entitlement. It's mine. Actually, working time is a public good and a collective good that must be distributed in a fair way. And the fairest way to distribute working time is through collective mechanisms. And I think the key point in this discussion is what we haven't really touched upon, which are the reforms to collective labour law. Because I think what we will see, I hope, is a growth in collective solutions as the statutory recognition procedure becomes more accessible and as consultation practices, I think, propagate out across the labour market. And I think in the end, that's the way that you get genuine accountability, where workers have a voice in the distribution of working time as a collective good.
Thanks, I really agree with that. Nye?
It's an interesting idea. I honestly don't know. I think my first hunch was similar to Alan's. I'm not sure that would be the main thing I would focus. I mean, so in terms of making these rights a reality, I think we have touched on it, but stronger enforcement, workers and employers knowing that there's an efficient and effective enough employment tribunal system such that if someone is denied and they have to take that individual recourse, they can do so. Because obviously at the moment we've got huge backlogs in the system. Employers know that. They know that employees will be likely put off going through that long 1 to 2 year process. So even though it won't change how any of this law is framed, if all groups involved know that actually they can seek redress and in a fairly speedy way, I think that would give much more teeth to everything that is being all the entitlements that are being given to individuals. In terms of reporting, I mean, obviously I'm a researcher, so yes, please give me a nice new data set that that monitors all of this. I'll never say no. But I'm not committed. I mean, because you immediately always get into questions of interpretation. Unless you know lots about the context of the firm, the context of the workers, it's always difficult to interpret that data. Maybe a firm faces lots of requests, but it genuinely is, maybe it genuinely does clear those reasonableness thresholds, and it is reasonable for them to say no, whereas other firms maybe not. And then also there's, maybe it's a good thing if a firm is facing lots of requests, they have the environment that means workers feel able to put in those requests. So, yes, please give me data if you want to create it. I won't say no, but doesn't feel to me like the most important aspect of it, but a good question. Thank you.
Thanks, Nye. Amy?
Thank you. Yeah, I would agree. I think if we were asking firms to report, it would have to be on the individual requests, which is only going to give us part of the picture. So it wouldn't encompass any of the kind of proactive whole team approaches that are actually what we're trying to encourage employers to do, to really make flex by default a reality. I guess it might give a little bit more teeth, and like Nice says, maybe, you know, employers would be aware that they're having to report. I think what we would really like to see is employers being more open, and that was that kind of reporting internally process that I mentioned earlier around the types of flexible work, the different contract types that there are. I think that's actually going to be more valuable to employees than data around, you know, 50 people asked and 32 of those requests were granted.
Great. Alice.
Thank you. I think in terms of the accountability question, I think as Alan mentioned, that the collective elements of the bill are really important when we're thinking about making rights a reality, and the accountability to actually deliver them. Parts of the bill will increase unions' accesses to workplaces. It will simplify the recognition procedure, and there'll also be the changes from the Trade Union Act in 2016. So I think these are really, really important. It provides employees with mechanisms to make sure that they are able to access their rights and that their rights are being met. And then it also provides mechanisms for workers to be able to collectively agree where they think their employer should go and above and beyond those rights and where that's possible in their workplace. Two other points on this as well. Tribunals, again, we know that we need huge amounts of reform to our tribunal system, that we currently don't have a functioning kind of accountability system through the tribunal network because of things that Nye mentioned, like extreme delays. We're seeing up to 2-year waits to access an ET due to kind of lack of judges, lack of infrastructure. But also at the moment, there is that 3-month less 1-day limit, which is a really, really short amount of time for an individual to kind of even realize that their employment rights haven't been met, then to do something about it, and then to get the legal advice. So extensions to that period as well would be very helpful. On the reporting mechanisms, I would just say a long-standing TUC ask is, if we are going to have, in things like gender pay gap reporting, action plans are really essential to go alongside this. It's very nice to have the data, but what we would like to see employers is then using that data and with unions having a conversation then about what action you take off the back of that data to close your gender pay gap or increase your access to flexible working or close your disability pay gap. So I think any data should come along with a requirement to take action on the problems that that data kind of reveals.
Great, thank you. Well, listen, there's been far more questions than we could possibly answer. So it's just as well that this is the first of a series of webinars. We will come back to them all. Thank you so much to our speakers for joining us, and to you for all of your questions. We do have a few more events in the series coming up. I think there's a slide which will show a bit on those, but I think we've heard a lot of consensus here around the importance of the sort of sectoral and workplace agreements that might be needed alongside the legislation. Unfortunately, we are publishing ideas on both of those aspects. So do join us for future events, and thank you again so much to our fantastic panel of speakers, and do enjoy your day. Thanks, everyone.